And we start with our distinguished guest, Professor Laurent de Suttera from Vrije Universiteit Brussels and Sciences Po Paris, who is a legal theorist, authored more than 20 books, I guess, translated into several languages, and also a very generous person who kindly agreed to share his time and thoughts with us here today at this conference. So, Laurent, I give you the mic.
Well, thank you very much, Aidan. You are the generous person. You know, I simply got flattered, and then I arrived. So it's more narcissistic kind of. I'm more narcissistic than generous, I suppose. So thank you very much for this kind introduction, and thank you very much again for the those responsible behind this, behind and in front of this conference. I'm very grateful for the invitation, even though I must confess that when I received the invitation, I had a moment of perplexity because of the name Stanisław Ehrlich, which I must confess, much to my shame, I had never heard of before. The only Ehrlich I was aware was Eugen Ehrlich, you know, the Ukrainian/Austrian legal sociologist of the late 19th century who spoke about lebendes Recht, you know, the living law, but that was the only Ehrlich I was aware of. So, as I said yesterday, I'm very grateful not only for the invitation, but also for all the informations and everything that I learned already about the character, but not only about him, about the more general context of what has been happening in terms of sociological thinking, sociological legal thinking in Eastern Europe during the 20th century. And chance has it that I will babble a little bit before entering, because I have lots of time, so you know, I'm entitled to say useless things before saying perhaps useful things. But 2 weeks ago, I was in Ljubljana at a conference where I had the same experience with, you know, the Slovenian, let's say, political history of Marxism with the Praxis School and all. And for me, it's a continent that opens, you know, from the Praxis School in Ljubljana, here Ehrlich in these discussions here in Poland. I realized that there's a long way to go, at least on the Western side, to try and get a grasp on all this, because we're actually not informed. And when I checked, actually there was only one book of Ehrlich translated into French, so his book on pressure groups, and up to my knowledge, only 2 in English. So it was okay. There's a lot of work to do. So, because I don't know anything about Ehrlich, I will not speak about Ehrlich, hence my perplexity, saying, what the fuck am I going to tell these people about something that, you know, that they know, you know, much more than I do. So, Christoph was very instrumental in, you know, putting this perplexity aside by saying basically that don't speak about Ehrlich, you know, don't even try. That would be an embarrassment for everyone. Instead, speak about it. That's an interpretation, you know. As you will see, I have wild interpretations of lots of texts. So he said, okay, I would like you to come back to these materials that took the form of this very small book that I published almost 10 years ago. That's called Magic, Metaphysics of Bond. So speaking about bonds, legal bonds, and this very strange idea that still permeates in sociological circles, especially, let's say, center liberal sociological circles, but also, you know, less liberal, more conservative circles. So the idea of the social bond, what the French call le lien social. I don't know how it sounds or how it resounds in English or even in Polish, but in French, it has become so proverbial, so automatic an expression, that when you hear the words le lien social, you know, social bond, there's a moment of, you know, you stop, a moment of almost reverence or supposedly reverence towards something that is so important, you know, so deeply ingrained in the very fabric of human societies, that there is nothing there to be even questioned, is there, like something which is absolutely obvious. So as I have a tendency to refuse to kneel, I have a tendency also to refuse reverence, which is perhaps another narcissistic tendency, I don't know. So when I hear this vibrato surrounding the idea of le lien social, I have a slight irritation, that I can feel in my body. And this irritation is often the trigger for my work, so also the trigger for the type of research that I'm trying to do. Meaning that I literally research things that I don't know about, so I could research Ehrlich. And very good choice of ring, by the way. And I try to be as faithful as possible to this fantastic sentence of Gilles Deleuze, when it said that nobody can speak better about something that he or she doesn't know about. And of course, the reason for it is if you don't know anything about something, you're forced to work a little bit, which is not the case when you know. When you know, you don't have to work, you become lazy. So what you say is uninteresting. So I've tried to make some kind of research behind this idea of lien social. Where does it come from? Social bond. Where does it originate? What does it mean? Why is it so important? And what is the reason of its positioning at such an superior, let's say, position in our sociological, social, but even political vocabulary? And I will start with some perhaps obvious observations, things that perhaps you're familiar with, namely the fact that until further inquiry perhaps, but the first occurrences of the idea of social bond can be traced back to 1762, at the moment when Jean-Jacques Rousseau published his social contract. It was a moment of turmoil, as you know, a moment of political turmoil, intellectual turmoil, biographical turmoil also for Rousseau himself, since the publication of the social contract just after the publication of L'Émile caused him not only to suffer, let's say, some kind of banning from the authorities of Geneva, but also some condemnation from the Paris Tribune. So it was a moment which was a delicate moment, which meant that the proposals formulated by Rousseau, not only in L'Émile, but also in the social contract, were proposals that were, let's say, considered as slightly deranged, because perhaps that's slightly deranging. You know, of course, the basics of what you can find in social contract, maybe the idea of social contract, general interest, and so on and so forth. But it's also in this text that appears for the first time, somehow, or the first time that I've traced it back, the idea of the social bond. The strange thing about this appearance within the discourse of the social contract is the fact that it's never defined. It's there, it appears at some key points, on several occasions within the text, but without receiving a definition and being considered already as something that goes without saying, something that seems to be obvious, and something about which all the other instances, all the other institutions that are described by Rousseau seem to be working to make it happen. So the social contract or the general will are all operations or operators that help fostering and grounding something like a social bond. The only thing that perhaps we can observe, and that's how characterizing it, is the fact that social bond as an expression is used by also in contexts that are always surrounded by legal overtones. They are not descriptions of a world. They are not descriptions. They do not designate the functioning of, I don't know, relationship between persons. They do not describe institutions. They do not describe political functioning of the world or, let's say, a spontaneous regime of relationship. But they describe places where law and especially rights are at stake. I will just read a quote. One of the most perhaps striking of these quotes. I will read it in French and then try some stupid clumsy translation. But he says that what matters here when we speak about fundamental pacts that bounds together the society around its generality, the fact that there is a society somewhere that transcends the individuals that are part of it. So what is essential about these pacts is that He says, le droit de chaque subordonné, the rights of every subordinate. Le droit que chaque subordonné a sur son propre fond est toujours subordonné au droit que la communauté a sur tous, sans quoi il n'y aurait ni solidité dans le lien social, ni force réelle dans l'exercice de la souveraineté. The right that every subordinate has on its own would be goods, let's say, on his own goods, is always subordinated to the right that a community has upon everyone, without which there wouldn't be no solidity in the social bond, nor real force in the exercise of sovereignty. So this is one of the, let's say, places where the idea of social bond emerges as some form of an object that works within the coordinates of both, let's say, political theory, sovereignty, but also legal theory, the rights that a subordinate meaning a member of the social contract, has on his own goods, so property rights, for instance, or why not parental rights, if we consider people as goods and so on and so forth in the old Roman tradition. The rights, of course, of the totality of the society, and then the question of its sovereignty. So this is something that has triggered some kind of a reaction to me, which is, yeah, that's strange to see that when the idea of social bond appears, it doesn't appear so much as a purely sociological descriptive or description of something that would be a society, but about something that has to do with the institutionalization of relationships, the institutionalization and formalization of relationships between people and things and so on and so forth, under the guise of some sort of legality, of some form of juridicity. And indeed, when you see how it has been then taken, appropriated, how it has circulated, not only, of course, in the contemporary period, but also in the work of the early proponents of sociology. Think of Émile Durkheim, who we have been discussing yesterday already. Durkheim is perhaps the first bona fide, let's say, sociologist to use this category, but to use it in a very sparse way, in a very rarefied way. He never uses the expression social bonds, prefers to speak, as you know, about solidarities and so on and so forth. So the idea of social bond is not used in his major works, but it is used in the commentary that he did on his second PhD, but also in some early article that was eventually published posthumously about Montesquieu on the one hand, and again, Rousseau on the other one. So Durkheim was very well aware of the place and the role that, let's say, that the idea of social bond played in the work of Rousseau too. I have to go back to my own copy in order to the small remarks I wanted to make. Yes, and the key feature, perhaps, like we can see there in Durkheim's commenting on Rousseau, is the fact that when he speaks about le lien social, like Rousseau did, the social bond, it's never about social bonds. It's never about liens sociaux at the plural. It's always le lien social at the singular. And this is, of course, what interested Durkheim, because when you speak about the lien social, of course, it's in relationship to rules, laws, institutions, and then perhaps also norms in general. But it is the lien social as there exists the society or a society. It's not about some sort of plurality of bonds that exist within a given space, but about the fact that if there is something like a society and its institutions and its norm, this society holds together, or is a society precisely because there is le lien social that ties it in some kind of a unity, in some kind of a unified, let's say, creature. So there is some kind of a parallelism, if you like, or some kind of a going together of law, rules, and institution on the one hand, the very idea of society on the other, and the idea of social bond at the end, meaning that if you take one out, that's at least the idea of Durkheim, you take all the rest out. So when you speak about society, what you are speaking about is always le lien social as embedded within these institutions. It's not so much about the life of people. It's not so much about the feeling and so on and so forth. It's not so much about what happens between one person and another. It's about the general, let's say, cupola, the general arc within which society is taken. There, for me, there is something that is striking about this sense of putting together a certain idea of society, a certain idea of law, and a certain idea of the type of bond that exists between people. And that's where Durkheim is interesting, because on the one hand, there is Rousseau in Durkheim, but on the other hand, as I said, and it's the other place where he speaks about le lien social, social bond, there is Montesquieu. And Montesquieu, again, I'm sorry to come back to these very old, classical references, but that's where shit happens, so to speak. So it's good to go back to them. So you might remember the very opening of The Spirit of the Laws, when Montesquieu describes and defines what he understands as precisely the laws. The laws, he says, are the necessary relationships. He says rapport. I don't know how to translate that into English. So the necessary relationship that exists between things. So it's about one thing being reported to another, or being linked somehow, or being bonded to another. And this report, or this relationship, this rapport that exists between things, for Montesquieu is quite interesting, because it is a rapport or relationship that does not predicate what kind of beings can be related together or can be bonded together by these laws. And if you read carefully, I spare you the details you're reading, you have to either believe me or just reopen The Spirit of Laws here. But you realize very soon that when he speaks about the spirit of the laws, what he's interested in is not society at all. It is not the relationship that exists between humans within some kind of a whole, but it's a relationship that exists between anything, including the laws themselves as something to which we can have some form of relationship within a totality that is not giving. So it's, let's say, the other way around, so to speak. It's the primacy of the relationship, the primacy of the bond upon what is bonded together, or what is related together with the bond, rather than the primacy of the unity in which the bond functions as a tensor, or as an operator of coherence, cohesion, and some kind of unity. And it's quite strange that Durkheim didn't make really didn't try to see, let's say, the type of tension that existed, or the type of paradox that there was, of holding together a view of le lien social from Rousseau on the one hand, and on the other hand, trying to see in Montesquieu the precursor of sociology, so to speak, based on a very definition of lien, bonds, or reports, or really a rapport or relationships that seem to go in the other direction. And of course, it's a point that has been made quite persuasively by Sutter in his Montesquieu, La politique et l'histoire, in his first book, when he was the first to indeed say, no, it's not. If you say that Montesquieu is not the founder of sociology, if he's the founder of something, it's the founder of perhaps political science, because he's not interested so much in society as he is interested indeed in these different realms of relationship. So when I saw that, I said, I told you at the beginning that I had a problem with the very idea of le lien social and how it was used in public discourse, most of the time it was to mourn something. It was to say, le lien social se défait, the social bond is crumbling, the social bond is dissolving, it is a catastrophe, because when the social bond dissolves, what will happen? And then you can fill the blank. Totalitarianism, fascism, blah blah blah. Individualism, whatever. The usual list of guilty horrors. Let's say that publicists love to put in their op-eds, and that public intellectuals like to play with like puppets to frighten little children that we are supposedly. So when I saw that, I said, okay, so there's obviously, and as often there's a misunderstanding there, or at least there is a problem, there is a tension. If le lien social originates in this strange context, if it is used by figures such as Durkheim, but others also in some situation of ambiguity, then why not try and dig a little bit deeper and try and understand what it means to bind? What is a bond? What does that mean, a bond? And then what could mean a social bond if such a thing exists? What is a bond? And of course, we can answer very stupidly, Bond, James Bond, but that wouldn't be a fitting answer. Also, I suppose. So what is a bond? It's not a 007. Sorry for this very cheap. It has something perhaps a little bit deeper to it. Whatever we think about James Bond, by the way, but that's another story. What is a bond? Stop laughing. you stop laughing. I would have to do another one, and that would be the end of it. You know? What is a bond? If we take seriously, also for a second, whether we appreciate or we don't, or whether we take seriously Montesquieu, we see again that if we speak about bond, we speak about, I said, law somehow, rules, norms. There's something that pertains to the world of either legality or juridicity that happens with the idea of bond. But if it is so, what can be the origin, perhaps, or the source of it? How the idea of bond also resonates at the time, for instance, of Durkheim with ideas that are legal. And you might be aware of that or not, but among the people surrounding Durkheim, among the members of the editorial committee of l'Année Sociologique, Durkheim's famous journal, there was a lawyer who was also somehow part of the family of some of those who were also part of the crowd, such as Marcel Mauss and his friend Hubert. And his name of this lawyer, legal historian, was Jean Huvelin. I don't know if you're aware of Jean Huvelin. If not, fine, because I was not aware of Ehrlich, so you were not aware of Huvelin. So we're square now. So Huvelin was a figure, a completely forgotten figure, who eventually wrote a little bit about commercial law at the end of the 19th century, early 20th century, but also published two very strange articles on what's called the De Fictio tablets in Roman law, and on the relationship between bonds, obligation, and magic in Roman law. And indeed, when you read Huvelin, when you open these dusty old articles, if you manage to find them, what you can see in them are quite strange observations, but that somehow resonate with what was happening not only in the historiographical circles, but also in anthropology at the end of the 19th century around the idea of magic and around the division or the divide that can exist between magic and law. And most notably, Mauss and Hubert's famous article on magic was based on the divide between, let's say, magical bond and legal bond. So there was something there that was looming in the air, so to speak, something that always brought back not only law, but very ancient forms of law, very ancient form of law that go back to the most archaic times of Roman law. And indeed, if we are speaking about bond, it's impossible, at least for me, to look at them without what makes them something that works. If it's a bond, if there is a bond, except if, of course, if you're into bondage, where it's very simple because you just need rope. But if you're not into that, how do you make so? Sorry, that was number 2. If you are not into that, let's say, and if you are indeed to have bonds that produce effects, how do you do? How do you do when these bonds are not materialized? How do you formulate some kind of a necessity that makes so that indeed one thing is bonded to another, or one person to another? How do you make so that this bond or this relationship produces consequences that are real, so to speak? The Romans had an answer for that. They were interested in that. That was for them the problem of law, the problem of necessity. Given the contingency of every form of relationship that we have, how do we make so that this contingency can be transformed into something with necessary consequences? How does it make that if I have this thing, I say this thing is mine, that this thing is yours in such a way that you can make so that nobody else can take it? How do you make so that when you are in this relationship with this person, say marriage, this marriage indeed has consequences for children? How do you attach a child to a married person? How do you attach one married person to the other married person? How do you make so? Of course, the answer is you cannot. You cannot if you are simply considering that this is a matter of language. And you say, no, we've said so, now perhaps there are social forces that will make so that, yeah, you know, people will be attentive to that because we've said so. For them, it was not sufficient. Or it was not sufficient also to assume that it's simply because there's police, if you don't respect each law, your head will be smashed. That was not sufficient enough because that was not necessary enough. That was still contingencies, but contingencies coming from the outside and adding their own contingency to the contingency of the bond itself. If we are to see some kind of a necessity there, this necessity should come from within the institution itself, from the fact that when you say something within a legal framework, it has consequences. And the first bond that the Romans described, the most archaic one, of which we see traces in the Law of the 12 Tables, but we know that it originates or it predates from far the Law of the 12 Tables, which is already quite a lot, as you know, is the institution of which Laurent speaks about precisely, but not only him, Henri Lévy-Bruhl and other, you know, completely forgotten scholars, is the institution of the nexum. The Romans had two forms of, let's say, relationship obligating people to do things in archaic times. It was the mancipatio and the nexum. Mancipatio was quite simple because you just had to, you know, literally give from one hand to another. So there was some kind of a transfer of the thing that would make so that the travel of the thing itself means that it's under your hand. Because it's under your hand, okay, there's something more or less assured in terms of relationship between you and what you have in your hand, you know? Nexum was another thing. Nexum was about debts. If you go to someone, you borrow money to this person, how are we going to make sure that you will reimburse this person? When you don't have banks where you can directly, you know, suck money on it and so on and so forth. So they came with this idea that they called the nexum. Nexum, which means nexus, necare, it's to bond. So this very idea of, this is a primitive idea, let's say, of what a bond is. Nexum is, okay, you can't say, okay, I owe you money, I promise that I will reimburse. Yeah, but your promise, you know what it was, you know, you just have to run away and then I'm lost, you know, I don't get my money back. So how are we going to do so that you will effectively pay me? Okay, nexum, what does it mean? You put yourself as a person, your body, as some kind of a guarantee. The guarantee that if you don't pay, the person to whom you owe money will take you under his custody and will use you as some sort of a modified slave, and you will work until you have reimbursed your debt. And in order to make sure that this is something a little bit serious, not only you, but some relatives upon which you are patria potestas, let's say your son or something, will be involved also in this process. Of course, there will be a procedure for that. kind of sacral procedure, you know, the per ies et libra procedure, where you have a form of few formulas to pronounce. You have to take a little bit of money on one hand, the equivalent in some kind of copper on the other, and there's some kind of a dance and so on and so forth. But then it's done. The formula is called damnatio, a damnation. So it's a formula by which you damn, let's say, yourself if you don't act according to the institution, according to the act that you just posed. And they were very happy with that. Okay, next one, that's good. So okay, where is the necessity there? How can we make so that the guy doesn't run away? Does it really helps? Or is it really different than just shaking your hand and whatever? For the Romans it was, and it was for a very simple reason, because the damnatio, the damnation, the formula, already had an effect. And this effect was not so much that you would burn in hell or to whatever place, or walk in the, you know, plains of asphodel or whatever until the end of ages if you don't fulfill your duties. Is the fact that the formula of damnatio had already transformed you, whatever the concrete effects it had. And this is a distinction that the Roman lawyers later on tried to make, is the difference between what they call the real effect of what they ended up calling an obligatio, an obligation, and what they call the obligatory effect of an obligation. The real effect is, again, like the emancipatio when a thing travel. The obligatory effect is the effect that something has upon those who are part of the contract, independently of their actual real effects. These effects are necessary effects insofar as they are produced by the mere, let's say, exercise of a certain type of language, or a certain type of linguistic regime of language, a regime that links language directly to something that goes beyond it while going back to it, namely the fact that language is always necessary. That is an idea that has been perhaps refreshed somehow by Giorgio Agamben in recent years, especially in The Sacrament of Language, when he describes precisely how language, if we are, let's say, if we want to look at it in something as something that is not simply gratuitous, it's not something that floats in the air, but something that indeed has also effects, we are to go back to the very idea that speaking is always something like cursing, if you like. It's always calling things names. And by calling things names, calling the power of what it means to call a name a name. And of course, the name of a name is always God. So when we are calling something, when we're speaking about something, we're always speaking somehow of the God that we are, you know, cursing or not. So there's this, what Agamben calls the command dimension of language, the fact that language is never about description, but always about some ought to be, or some, let's say, deontic dimension, was something that the Romans were very well aware of. And that's where the reflection on magic becomes a reflection, or the thinking about magic becomes something which is something, at least to me, decisive. Because this effect of necessity that goes with the very performance of language, and that provokes a transformation, not of a real situation, but of the ontological condition of those who are part of the bond, is exactly what magic is all about. Magic is not about abracadabra, it's not about, you know, filters of love, and it's not about Harry Potter, even though in Harry Potter there are interesting things about magic, you know, as anti-capitalist power. So magic is about how do you make so that something that has happened indeed has happened, and has happened in some kind of a necessary way. And I think that this idea of transformation at the level of ontology is still what law does today. meaning that even the most simple obligation that we can have, go to the shop, we buy, cigarettes, or we buy a bottle of water, our relationship to the bottle of water, our relationship to the seller, our relationship to ourselves has changed at the very moment when we did the purchase. We have become, from someone who is no one, somebody passing by, we have transformed ourselves in a buyer. And a buyer has obligations, has a buyer. If we don't observe them, we can run. And perhaps the police will never catch us. But we're still a buyer, and we're still a thief, whatever we like it or not. Type of necessity, let's say, of the operation of bond here has altered us in the same way as married people, again, are altered by the way that they declare themselves married. So back to the idea of social bond. If a bond originates in central contexts where magic, necessity, language, cursing go hand in hand, what does it mean when we zoom out? Is it only possible to zoom out and speak about social bond in the same terms of necessity? Durkheim was not interested in thinking about that. Rousseau was, as a matter of fact, not interested in thinking about that. Montesquieu was a little bit more interested about that, but it was not perhaps the only one, and perhaps the most interesting theory that we can think of about the link between bond, magic, and perhaps a certain definition of a polity that wouldn't be a society could be found in Giordano Bruno's, for instance, in these small esoterical treatises that he wrote before his trial and execution, these two treatises on precisely magic on the one hand and on bonds on the other, two treatises that kind of respond to each other. And the description of the world that Giordano Bruno gives in these treatises is a description which is closer to Montesquieu, but so far away from Durkheim. It's, of course, some kind of a very strange tree of relationship that is ever changing, and there's, of course, always God on the top, somehow. But a tree of relationship that makes so that the power that God has to create, let's say, the world, that is to create the very order of bonds, but being taken by this order himself, because the necessity of bonds is a necessity that he is not to decide. The necessity, let's say, predates him, so predates his creation. Everything that is under shares with the very power of God, the power of using his necessity. So it's both a vertical and perfectly horizontal or democratic, let's say, society where bonds is always about this bond with this bond with this bond with this bond, where the capacity to produce a bond is a capacity that's absolutely equal between all the participants, whatever their ontological reality, be them humans, animals, a thing, a bird, a fiction, a god, and so on and so forth. So there something which is quite provocative or quite different, perhaps, compared to the traditional understanding that we have of a society as this group of human beings that somehow cohabitate with domestic animals, that have different relationship with wild animals, again, different relationship with animals that we eat, and then who use things, and then who are represented somehow into some kind of political institutions that formulate the rules of good behavior of these people, etc., in the space, etc., etc., etc. Here, what we are is the primacy of how one thing, whatever it is, bonds with another, in the sense that this bond is not given, it is made. But this constructed bond is not simply constructed, it is reconstructed always, meaning that it transports its necessity and its capacity to reproduce and displace and transform its own necessity into some other context. It means that a bond never is something that ties in the sense of makes us or makes things immutable or renders it impossible for them to have any sort of move or agency. It's quite the contrary. It's the bond that almost forces us to change, because with it goes the force of necessity that it carries. So that's the idea that Bruno had, somehow in a very, of course, different context. And that's the idea that the greatest rival perhaps of Émile Durkheim, so Gabriel Tarde, read or understood perhaps in Bruno, understood perhaps also in Montesquieu, understood in all these visions and theories and ideas, and understood also in Dublin, understood in these scholars who reread Roman law at the light, let's say, of magical thinking, when he spoke about law in a different way, not law as something that belongs to a certain society, that it somehow, from which it emanates, that it illustrates, and upon which it comes back, like in some kind of systemic circle. Law has nothing to do with systems or systematic thinking. It has only from a certain political perspective, so to speak. But law, if it has something to do, and something to do that has nothing to do with legislation, but with operations, such as the operation of obligation, which is an operation, by the way, it's an operation that has never been decided by any court, that has never been decided by any parliament, that has never been decided by any government. There's no one ever that has said, now obligations are a thing that we are to obey or follow. It has been bricolaged, if you like, by some lazy aristocrats who loved legal sudoku, around the year zero of the present, let's say, the present era. So it's something which is absurd, let's say, to some extent, but it's an intellectual creation that has nothing to do with political institutions or nothing to do with legal institutional tribunals, and so on and so forth. And the same is true for all the major legal institutions that are still form the basics of our everyday life today, not only obligation, not only filiation or adoption, and so on and so forth. None of them had never anything to do with what we think are, legal institutions, and so on and so forth. These are operations, juridical operations, very distinct from legal life. Okay, and again, Tarde was very well aware of that, and this, let's say, Bruno Montesquieu tradition shows that indeed there is something there that we can say or see about the functioning, not only of law, but the functioning of our relationship through law or with law, which is what Tarde called the extension of the magical circle. Tarde was not exactly, he was a judge. He was not exactly some extravagant, crazy kind of fool, but he spoke very clearly about what he called the extension of the magical circle, meaning the extension of the fact that bonds can be used as tools to multiply forms of relationship with forms of being, rather than crush them down within, let's say, a monotonous and unified regime of coexistence. So what he saw as a society of obligations, as a society of bonds, so as a magical society, it's not a society precisely. It's not the Durkheimian society. It's not the Durkheimian lien social or the Durkheimian social bond that for him wouldn't have any sort of meaning whatsoever. But how do we appropriate the power of necessity of bonds in such a way that we reconcile ourselves with their transformative form, with their almost anarchistic dimension? Anarchistic meaning without principle or without another principle than their own necessity. So it's a strange understanding of law. It's a minority understanding of law. It's an understanding of law that didn't have much success, that still does not. But at least it's an understanding of law that asks a question about the certainty that we have that expressions such as social bond are expressions that go without saying, and that describe, without the need of interrogating ourselves, a certain form of reality with which we are supposed to comply. There is there a call, at least, and a call that personally I find interesting, but it's up to everyone, a call for reimagining not legality, but juridicality, legal operations and not legal norms, as something that precisely helps us think beyond the realm of rules, beyond the realm of principles, beyond the realms of ought to be's, beyond the frontiers of the deontic beyond normativity. Law, if we understand it like that, and there are other dossiers or the files that could help in putting some arguments on the table to defend, let's say, this view. If we think about law in terms of operations, such as obligation, the type of bond that it produces, the type of necessity that it produces, then of course law has nothing to do with norms. Norms, if they exist, perhaps they do, it's different. Let's say it's politics, if you like. But law is not about norms. It's about how you make norms fail, how you invent possibilities that renders norms, let's say, helpless. And indeed, that's what has happened repeatedly, time and again, let's say, through the ages. And this is perhaps where this little, this tension, let's say, within the vocabulary of bonds and vocabulary of the social bond help us remember. And this is the message I wanted to share with you this morning. So thank you very much for your attention, and looking forward to the eventual discussion, trash, tomatoes, questions, hugs, anything. Okay, thank you.